Good evening, everyone, and welcome. For those of you who don't know me, I'm Anthony, first junior clerk at St Philip's Chambers on the family team. Tonight, St Philip's has the pleasure of hosting three specialist financial remedy judges to provide an update from the Financial Remedy Court. So please, let me introduce His Honour Judge Rowland, District Judge Ingram.
Hello there. Good evening.
District Judge McCabe.
Hello.
And here from the St Philip's family team, Julie Talon, who will be fielding your questions tonight. So without any further ado, let me pass you across to Miss Allen. Thank you.
Good afternoon, everyone. Thank you for joining us this afternoon for our webinar. We're delighted to be able to host our specialist panel of judges. Just to confirm a few preliminary matters, the purpose and the focus of this webinar is really in relation to procedural matters and an update from the Financial Remedies Court as it's operating in Birmingham and the Midlands. So in terms of any substantive legal matters, we're going to leave those for another day. So my apologies if you have submitted substantive legal questions that you hoped the judges might answer for you today. I'm afraid we're not going to have time today to deal with those sort of matters. But any of you who have pre-submitted questions about procedural matters or the Financial Remedies Court, particularly COVID-related matters and an update on where we are in these unusual times, that's very much the focus of the webinar, and I'm going to be raising those questions of the panel on your behalf this afternoon. There is also an opportunity for those of you who haven't raised any burning questions you may have to raise those via the Q&A function on Zoom. So if you find the Q&A function at the bottom of your screen and type your question, there will be hopefully time for a section at the end of the webinar for me to raise those questions on your behalf of the panel. So go ahead, fire away, raise those questions now. So without any further ado, I'm going to hand over to His Honour Judge Rowland, who's going to give a brief address on where we're at in terms of the Financial Remedies Court in Birmingham. Thank you very much. Oh, Judge, you're on mute.
Yeah, I've unmuted. Can you hear?
Yes.
Good evening, everybody, from the Financial Remedies Court. My brief introduction is going to be to explain where we are currently as far as the administrative side and what we're offering to litigants here in the in the Financial Remedy Court around the West Midlands region. To start off with, let me go back to early March and where we were then, before the lockdown. We were falling behind in the administrative side. I think orders and correspondence had gone back to about a month or thereabouts, which was not where we wanted to be. The court staff or the administration had recruited several new staff members to join the financial remedy team. Of course, they needed to be trained. It was at that point that the lockdown as a result of COVID-19 hit us. And the financial remedy staff were decimated. For several weeks, there was only one person manning the FRC section, whereas we generally expect to have about 10 at full strength. That member of staff performed Herculean efforts to keep some sort of system running. Essentially, her work, by and large, was to keep the listed cases capable of being heard to a large extent. And so we didn't have the existing staff, we didn't have the new staff members who can't be trained remotely. And HMCTS decided that they were going to try and provide laptops for people to work remotely. Unfortunately, the nature of procedures with HMCTS has meant that those laptops were very slow to come about and be provided to people to work remotely from home. That has started to happen now, and I'll come to in a moment to where we are at present. The other thing that, of course, happened when the lockdown began was that all the hearings that everybody had assumed would be attended hearings couldn't go ahead. So FDRs and final hearings in the first couple of weeks, we generally had to vacate. And first appointments we tried to turn into remote hearings. That was for the couple of weeks leading up to the Easter break. And since then, of course, we've been guided by what the President of the Family Division, the Lord Chief Justice and the other senior judiciary have said. There have been no attended hearings between essentially mid-March and the very recent past. So bringing things up to date, with staff coming back, we have begun to address the backlog. But regrettably, we are still at the point where orders and correspondence are at a date in late March. That's where we're dealing with orders and correspondence currently. In answer to one of the questions in a moment, I'm going to deal with where we are about the issue of new Forms A. As far as the court building here in Birmingham is concerned, and this reflects, I think, what is happening across the region, there have been health and safety assessments to work out what is possible for people to come into court buildings with safe distancing. Here in Birmingham, there are more than 50 courtrooms. The initial advice we were given was that we could have about 8 courtrooms operational at any one time to enable, either in the courtrooms or more realistically in the common parts, for everybody to be socially distanced at 2 meters from one another. More recently, there's been further investigation, and it seems likely we could have some greater number of courtrooms used, maybe 12 or so, while we have to meet the 2 meter social distancing requirement. Of course, if that reduces to 1 meter, then that's going to be far easier to have more people coming into the building. But it's the same problem across the region in other court buildings. The number of courtrooms that can be used, the number of district judges' chambers is very limited. And that's one of the real difficulties about having an attended hearing. So I think one of the lessons that undoubtedly needs to be passed to practitioners is that if you want to have an attended hearing, you're going to be struggling to have it heard up against other jurisdictions, because in combined court centres, the Crown Court will have real problems in dealing with their backlog, and in ordinary county courts, there's going to be competition with civil for their cases to be heard. And of course, there'll be possession hearings where people have to attend in person. So also looking to the future, given that first appointments by and large are going to be telephone hearings, we're providing for longer time slots for first appointments. They're going to be 45 minutes for a standard case rather than the current 30, to give time for the dialing in, the introductions and the inevitable additional time that's taken. I would encourage the use of the accelerated first appointment procedure, so that if you can get your order for the first appointment agreed and submitted, there should be no need for a hearing to take place. My view, and we'll come to this in answer to one of the questions in a moment, is that after the first appointment, for FDRs and final hearings, they ought to be conducted by some form of video platform. And that's going to be by far the most suitable method to achieve a good result. So that's my brief introduction, Juliet. I think you want to have contributions from the other judges.
Yes, thank you very much indeed for that. And I know we'll be coming back to you with some of the questions in a moment.
Thank you.
I was going to turn next to District Judge Ingram for her reflections on where we're at now in the middle of, and certainly her experiences of conducting financial remedy work remotely. So over to you, Judge Ingram.
Thank you, Juliet, and good evening, everybody. As long as you don't tell my DCJ in Birmingham, and I know we're being recorded, the majority of my hearings in lockdown from home remotely have been financial remedy hearings. It's the way the work was allocated, the way that we needed the specialist work to be covered, and obviously there were many judges in the building having to disappear home at very short notice. We had to learn the IT and the technical side of matters very, very quickly, and it was a steep learning curve. As you know, we haven't done any remote hearings, certainly by Skype or Skype or Meet Me, or indeed Teams, for some considerable time. I'm just wondering if Robin could mute his microphone, if you wouldn't mind.
I thought I was muted.
I'm so sorry, I've got a lot of feedback. That's brilliant. Oh, that's brilliant. So sorry, thank you. I had a lot of feedback. Thank you so much. So preferences, I'm going to start with remote working preferences. There does have to be uniformity in Birmingham so that we can get more routine standard orders out. So the routine default, if you like, for first directions appointments will be more likely than not BT Meet Me. And then for FDRs and other hearings thereafter, likely to be by Skype or Teams. My personal preference, and I know that's a Judge Kelly, who's been doing quite a few of the other remote hearings, and I think as well Judge McCabe is the same, is we do prefer Skype or Teams. The reason for that is that for BT Meet Me, working remotely, we don't have the staff at the moment to assist us in the ringing around, and therefore we have to do it ourselves. And if we ring round possibly 2, 4, 6 parties, because obviously invariably the husband is in one home, the wife in another home, their solicitor and counsel, etc. You can easily call at least 6 people, sometimes 9 if there are interveners. It can take 15 or 20 minutes. So we would ask that if we have to do that, you're patient, and that you notify the parties in advance, including your lay clients, that they're to sit back and be patient and wait, that it might not be dead on 3 o'clock we phone, it might be 1:15, and they don't use the time in the middle to panic and call their solicitor to say, where's the call, because then they're going to be engaged and we can't get through. So I do send some notes out, if I can, in advance to the parties' representatives to remind them to do that. But if you can yourselves be aware of that and have a back line or back chat with your clients, another phone line, another mobile or email or something, so that would help the communication. Skype is certainly our preference, and certainly myself and 1 or 2 others will be converting as many as we can to Skype. The reason for that is I think a lot of parties are starting to feel that the hearings themselves are very informal. They think it's a chat. I'm sitting in my office at home upstairs, we're all in our homes, etc. Or even at court, those in court are sitting in the chambers. It doesn't look like a courtroom. So what's invariably happening is that people think they're having a cosy chat and they don't believe it's a court hearing. Now, I find that personally worse on telephones, on Meet Me, because they use that, often husband or wife, even if they are represented and their solicitor or counsel is still on the phone as well. they still want to wade in and use it as an opportunity to bicker at the other spouse. So it is very difficult sometimes to control that and make them realise that it is a court hearing, it's still a court hearing, and it's still formal, and they should behave as if they're in court. So again, if there's anything you can do in advance to your clients to make sure that they respect the fact it's a court hearing, they're using up valuable court resources and time. As you've heard Judge Rowland say, we're having to allow longer for these hearings because they're taking longer basically to set up and deal with, and ask them to please be patient and respectful of the court and basically shut up until they're spoken to. And I hope that doesn't sound rude, but if they don't do that, it's just ending up into a big free-for-all, and the hearing becomes uncontrollable. On Skype, of course, it's easier to wave and they see the whites of the court's eyes, and you can sort of get a bit cross with them and even wave your finger if you need to, and control them back in. So it is easier to do that on Skype than it is on BT Meet Me, but it would help if, again, you warn your clients that it's a court hearing, they should behave as such. I have had clients in the middle of their hearing, when I'm talking to them, disappearing. I know you like to do that when you're in my courtroom in Birmingham, but at least I've probably had the chance to say, wait, hold on a minute, where are you going? It's more difficult if all of a sudden somebody in shop disappears. And I've had people literally, while the hearing has been going on, going away to make a cup of tea. And on another occasion, I said, well, where are you going? And she said, I've had to give my child a drink. And of course, I understand that children are at home and we need to address their concerns, but this child was 10. And therefore, if that child wanted a drink, it should have been able to get its own. So if you can do anything at all to prepare your clients, I'd be very grateful, because it's difficult enough trying to bluntly control litigants in person. Just 2 quick points, because I might have used my time. Talk to the other side, please, in advance. Make sure that you do your best to narrow issues and come to an agreement, and at least discuss what you think the issues are. A number of people are coming online onto these remote hearings, haven't discussed anything before the hearing, haven't talked before the hearing, or even emailed exchanges to narrow issues. And that does waste a lot of court time and make the hearing sometimes a little bit unwieldy. One of the other points that I'll make, which we'll come to a bit later in dealing with one of the questions, is preparation of documents in advance, e-bundles, and the filing of such. We'll talk more about e-bundles later when dealing with one of the questions that have been sent in. But certainly in relation to documents and position statements, etc., if at all possible, please make sure it goes direct to the judge if you know who the judge is, because that's the way we will get them quicker. You probably know that the IT system, the case filing system we've got at the moment, is not a case management system. And it is very difficult to navigate as a judge to find where the documents are, what the relevant documents are, and indeed what documents you need for that hearing. They're very difficult to find and navigate. Therefore, if you can send any of the core documents direct to the judge, even if it's seconds before the hearing, when you know exactly which judge it is, please do so, because that will take navigating the documentation so much easier and quicker. So I think that may be my 5 minutes or so, if there's a smile or there's a thumb up, and I'll deal with bundles and e-bundles a little bit more in more detail later. Is that okay, Julia?
Very helpful indeed. Thank you very much indeed.
Thanks.
For those observations. I think everyone's going to find those really helpful in terms of preparing for their remote hearings. If I could turn now, please, to District Judge McCabe for her own reflections on the remote work that she's been undertaking, I think in both Birmingham and Coventry since lockdown began. Thank you very much.
So I think I've got sort of 3 top tips. One is get organised. Check your technology. It's not good enough, I think, at this stage of the lockdown, still to be receiving emails in from professionals saying, I haven't got Skype for Business, or I haven't got Teams. I understand you may not have Skype for Business, but Teams has been made free by Microsoft. It's readily available. I was charm itself in the first couple of weeks where people had difficulties. I don't really expect that now. And where I've got counsel and solicitors unable to get their sound working, unable to join a hearing, by this point, I really think that shouldn't be happening. And it's incumbent on the professionals to be checking your own technology. Check an hour before the hearing starts whether your sound is working, and don't say to me, oh, I've just had a recent update, it might not be working. That's not going to get a particularly charming response, I think, at this stage in proceedings. I think the view you'll get from a district judge like me is, if I, with my absolute failing in IT, lack of any understanding and ability, no support, no training, have been able to conduct hearings for sort of 12 weeks now, I think you guys have got a much better chance of being able to succeed. Her Honour Judge Walker and I taught each other how to use Skype for Business by making calls to each other and learning it that way. So really, I think that's now going to be the expectation. And get organised before the hearing, as Judge Ingram has said. In my experience, the care solicitors really led the way very quickly. They always had a Teams meeting 2 hours before every hearing. They always had a draft order circulated before the hearing. They'd always narrowed issues. And it actually became quite slick and quite focused, the hearings that we had. I had an FDR this week where the solicitors involved hadn't even spoken to each other before the start of the hearing, which was disappointing and wasted time. It was also a career low because we got £18,000 apart and couldn't settle. So, I mean, that's mortifying for me to admit, but probably linked to the lack of communication. Communication is key with opposite numbers, but also actually, I think, with lay clients. My most successful FDR experiences that I've had have got as close as possible to replicating old-fashioned hearings. So the cases where I've had solicitors and lay clients sat together at solicitors' offices, obviously appropriately distanced, and in some cases counsel, solicitors and lay clients all in the same room, have seemed to me to be much more efficient. Instructions can be given and taken very quickly. The client is feeling much more supported. If they can get Primark open, I suspect we can get people sitting in boardrooms and large offices and counsel's chambers together. So that's really something to think about. I think those hearings work much better. And lastly, penultimately, documents. Entirely agree with Judge Ingram. Documents are even more important. I've always said we want a nice spoon-feeding position statement. You might reasonably assume your judge has not got access to any other documents. Put it all in there, make sure there's a schedule of assets in every case. We're even more reliant now on sensible documents. And lastly, don't posture. It doesn't translate very well into remote hearings, I find. Perhaps what might have worked in a courtroom and looked like it might score some points really doesn't. I think people have got to be far more realistic, narrow the issues and really only take the points that need taking now. And I think that was within 5 minutes.
Thank you very much. That's really helpful. I think we're all going to be making sure we're testing our Skype furiously for every hearing. And I'm sorry to confess that I think I certainly had a technical Skype issue, but I first appeared before you. It was a very long time ago. But I think our systems are all well tested now, and hopefully everyone's got that up and running. So I know we have had one question already that I'll just deal with, because it kind of slots into what you were saying there, which is somebody's asked already on the Q&A whether Skype for Business is still available and whether it's not being phased out as a product. And I think you've given them a direct answer already, Judge, but it was just to understand that Skype for Business has been replaced by Teams. So Teams is the Microsoft replacement product for Skype for Business. You can still get and download Skype for Business if you have a Teams account. So it is still a product that's available, and it's sensible to get yourself a Teams account, which will enable you to work both Teams itself and, at the moment, Skype for Business alongside it.
Could I just add in, if I just may say there as well, sometimes we send out invites through Skype for business. You can accept the invite without having Skype for business, and you can log on as a guest. So don't be frightened if it does come through as Skype for business. If you haven't got it, it is still usable through the invite system.
Thank you very much. So moving on to the questions segment of the webinar now, and I'm going to start by raising a question that I have for the panel, which is this: is there likely to be any capacity for financial remedy final hearings to be heard in person for the remainder of this year? And depending on the answer to that, the next part of it is, what about going into the early part of 2021? Is the position that all financial remedy hearings are realistically going to be heard remotely for the foreseeable future?
I think I'm dealing with this one in the first place, Juliet.
Thank you.
I think the short answer is that here in the court system, we're planning on social distancing being in place for the whole of this calendar year and probably up to Easter next year. As I indicated before, it does to a degree depend on whether it's 2 meters or 1 meter. But if I take it on the basis that we stick at 2 meters, the reality, as I said before, is if you want your final hearing to take place, it's going to be much more likely to happen as a remote hearing than an attended hearing. We've got to divide up the court estate between civil and family and criminal as well in combined court centres. So the question is, where are financial remedy cases going to be in that pecking order? And obviously there will be a lot of children cases in the family jurisdiction which have to take place as attended hearings. So I can't give you a definite yes or no, but what I can say is remote hearings are much more likely to take place effectively. Bear in mind as well the possibility of it being a hybrid hearing. You might, for example, have one party who has to attend for part of the hearing with his or her representatives in order, say, to give oral evidence, with the rest of the hearing being conducted remotely. So you need to be creative about how you list cases. And certainly from the judicial perspective, we're finding that if you're going to have these hearings, whether hybrid, remote, or attended, in an effective way, they have to be case managed to within an inch of their lives to make them effective. I started a final hearing yesterday in a financial remedy case. The first witness was called. There was an intervention that we're dealing with over the first 2 days. And it transpired that the witness, who was the intervener, didn't have any of the documents. We had to abort day one. These are things that people have got to give serious thought to when setting the hearing up. Does that deal with your question?
It does. Thank you very much. Yes. I mean, that's the sort of point that's just so easily overlooked, I think, until you get into the habit of setting these hearings up. The idea that in order to cross-examine a witness, they're going to have a copy of the bundle, potentially, so they can take into certain documents. You know, it seems fundamental, but very easily overlooked. So
absolutely.
For that, how would you recommend that we factor in the remote element when looking at time estimates for final hearing? In your experience, is it a double time estimate or perhaps something less than that?
I think less than that. The one exception I'd say, if in any remote hearing you have an interpreter and the interpreter and the party who requires the interpreter are at different locations, you will probably have to double the time estimate, because the lag in every sentence being interpreted with a pause means that it's a painful an extremely slow process. So yes, definitely double the time estimate for that sort of instance. Generally though, if you don't have interpreters and you've got say a remote final hearing, I would have thought maybe a 20% increase to take into account possible IT problems, the introductions that you have, and the way generally remote hearings just tend to go at a slightly slower pace so that everybody can feel that they've had their say, means that they are extended in terms of the time of the duration.
Thank you very much. I know that there's a slightly different practice in Coventry, so I'm just going to turn now to District Judge McCabe to address the Coventry listing arrangements for final hearings.
Yeah, we're just fortunate in Coventry that well, or very unfortunate, the limited number of people we can have in the building means that realistically probably only one public law case can run at a time in that building. I'm well aware of where financial remedy work is likely to fall in the pecking order in the competition for court space, and it's low down. So I've sort of persuaded my court there that if we could get 4 people involved in a case, i.e. 2 parties and 2 lawyers, and that nobody else was going to be coming into the building, we could conceivably be running a financial remedy court alongside the public law court. So I think, well, I know we are listing over the summer, we're starting to list final hearings that need to be listed in that way. So I think I somehow accidentally, here's me telling everyone to be brilliant with technology. I was about to type an answer to Leisha Bond. In fact, I clicked on answer live. The answer is yes, we are going to be hearing final hearings remotely. More on which ones should be remote and which ones might not be remote. But I think everybody acknowledges, of course, it's a given. We would rather be doing hearings face-to-face in a courtroom. Of course we would. I think we're just more likely to be able to start that more quickly in Coventry than in Birmingham due to just the building layout.
In fact, the next question is one for you as well. So sticking with you, please, if we can. Are there any features which you consider would make a case unsuitable for a remote final hearing?
I've been sort of struggling to think about how I might answer this given the most recent guidance, which is obviously mandatory reading for all of us, which is Alistair MacDonald's brilliant case of Lancashire County Council and M. It's interesting to see how the language has changed, I think, from the early days of the lockdown and the sort of early decisions that came from on high. The test now, according to Mr. Justice MacDonald, is we have to consider the extent to which a remote or hybrid hearing will provide the judge with a proper basis upon which to make a full judgment. Adjourning cases indefinitely for many months for face-to-face hearings is unlikely to be a proper course where there can be an effective and fair remote hearing. Now, when thinking about what can be effective and fair remotely, I have had to give some reasoned judgments on this recently because it's been contested between the parties as to whether or not it's suitable for remote hearing or not. And the general suggestion that we are given by advocates trying to argue that it has to be a face-to-face attended hearing is credibility. Well, you can't assess credibility unless you can see the body language or see the person, see them reacting in the courtroom with everybody else. Alistair MacDonald's case, the Lancashire case, is brilliant to remind judges that really we shouldn't be basing our decisions on what is the body language in the courtroom, that it's far more likely that we are to be assisted by internal inconsistencies in the evidence, inconsistencies between the evidence and other evidence or known facts. So it's sort of moving away from this old-fashioned idea of having to look at how people respond in the courtroom. For me, I think the biggest issue that would persuade me that it isn't suitable for a remote hearing would be sort of procedural unfairness rather than substantive unfairness. If you had a party that couldn't manage the technology, if you had a party that couldn't participate effectively, if you had unmanageable documents because you'd got several interveners or the interpreters or the advocates, as in intermediary style advocates rather than anything else, that would lead me, I think, probably more than the issues in the case. So it's sort of really, for me, the key thing is, are the parties fairly and properly and fully able to participate? And where the answer to that is no, that's where real alarm bells would be ringing for me.
Thank you very much. A similar question, but now in relation to remote FDRs, and this is one for District Judge Ingram. Are there any features which you consider would make a case unsuitable for a remote FDR?
A lot of the points that Louise has mentioned may need to be considered for the background for an FDR. But at Birmingham, what we've mostly done is decided that pretty much all cases are suitable for remote FDRs, apart from those that have probably two litigants in person, a litigant in person, nobody represented at all. I don't think I've yet done an FDR that I've had two litigants in person. I think the main reason for that at the moment is there's such a backlog, and because we are having to do less cases than we otherwise would have done, we have to choose those cases the best we can that we know will be suitable for remote hearings. And bluntly, at the moment, it's those that have at least one represented party. I've done them with one represented party and one unrepresented party, and it's worked well, and we've actually achieved a settlement. So it is possible, but I think at the moment, two unrepresented parties would be very difficult, because with FDRs, as you know, we deal with them, we deal with the case, we hear their cases, we then give our view, and we then ask them to go away to talk about it. And of course, that's going to be very difficult. They're not probably going to do that very readily. And the only way I suppose we could do that is almost stay in the room and listen to the discussions with them, or allow them to use the platform to do that. But my gut reaction is, I think if you've got two unrepresented parties, it's highly unlikely that it's going to go ahead remotely at this stage. But of course, as Robin has said, if we're still talking about remote hearings in April next year, and we've cleared a lot of the backlog where we think we can actually do some, knock some cases on the head, then we'll have to probably rethink that and give every case a go. I hope that answers the question.
It does, very much so. Thank you. I know it sounds like a really difficult task trying to conduct a remote FDR with two litigants in person, so I can well imagine that may not be viable at this stage.
Bad enough sometimes with the solicitors, let alone with two litigants.
Yes, yeah, right.
Sorry.
Moving on to some questions now that have been submitted in advance of today's webinar. And there are really four quite similar questions, all to do with delays in issuing Form A's and delays in listing hearings. And those are questions from James Osborne of Harrison Clark Rickabees, a similar question from Anne Thompson of FBC Manby Bowdler, a question from Robert Adams of Wace Morgan, and a question submitted, I think today, from Richard Barge of Aaron and Partners. And I won't read the individual questions, but they all go to the issue of essentially when are the current delays in issuing Form A's going to be resolved? And in particular, why has there been, or has there been, a blanket policy on not issuing Form A's since lockdown began? Why is this, and what's going to change? So I'm going to deal with all those questions together on this issue of delay, really, in issuing, and I'm going to hand over to His Honour Judge Rowland to deal with this point.
Yeah. Well, thanks, Juliet. I'll deal with that in two ways. One is to explain why the problems come about, and it's not a policy decision not to proceed with these applications, and then I'll tell you what's going to happen. So it's come about for two reasons. The first is because of the depletion of our staff here at the hub in being able to handle new applications. As I said earlier, we've just had to try and look after the cases where hearings have already been issued or been allocated to keep them on track. The other reason is that the individual hearing centres haven't until recently been able to send us their lists of first appointment dates, because the system works by the hearing centres, Telford, Worcester, Wolverhampton, wherever, sending us a load of dates when they can list first appointments, and then Birmingham slots the cases into those dates and issues the Form C. So that's what's happened so far. The situation as of today is that we are currently processing Forms A issued on or after the 18th of March. For cases which have gone through the gatekeeping process and are waiting the allocation of a first appointment date, we're still dealing with cases at the end of February, but that is now going to start moving forward. I think essentially that the barriers are now to a large extent unlocked, but it's going to take a while again for us to catch up. Partly that's not going to be assisted in one respect by the fact that we've got to allow 45 minutes now instead of 30 minutes for first appointments. So that means fewer cases per available list. But we're now getting the hearing dates released to us by the hearing centres, and we're slotting those cases in. So apologies for the delay, but I hope you realise why it's happened.
Thank you very much. And just to deal with a specific question, when would you imagine that applications made early in the year might be listed? Are you able to give a sort of estimate on that?
We have to list them now. It's what, 12 to 16 weeks from the date of the Form C. So they're going to start coming through for first appointments now in the summer, late summer.
Thank you very much for that. A question now from Antonia Kirby, which was, going forward, how do you envisage the court will balance health and safety, the efficiency of the new remote way of working, and the sensitivity and humanity required in family matters, which is often lost over the phone? And that one's going to be answered by District Judge McCabe.
Yes, I think the interesting part of that question is over the phone. My experience is the phone is absolutely the worst of the options. It is far more difficult for the court, and I suspect for everybody involved in the hearing, to proceed by telephone. That's why we're so keen on Teams being in place of the telephone. I mean, the answer is we can only do our best. And I think I have sort of reflected that we may be making this all sound really easy and positive. It has actually been a total nightmare. Speaking personally, it has been so difficult to overnight adopt to a completely different way of working, as I've said, with pretty much no support, no technology, no resources. And we can only do our best to try and ensure that there is still a humanity and some compassion and some sensitivity in what's a really difficult area of work. What I try and say to myself personally is, if there are judges trying to work out who's fractured a baby's skull remotely, I just have to roll my sleeves up and try and apply the Section 25 criteria and just do the best that we can. And I think that's all any of us can do. What does worry me about reading the Lancashire decision that came out today or yesterday is the suggestion that we will be limiting the time allocated to hearings and allowing less to be litigated or ventilated in hearings, and that things that people might want to ventilate. So there's going to be some fairly robust case management, and I think that will be hard for all of us to get the balance right, essentially allowing less time for hearings than otherwise we would have been, but maintaining the kind of compassion and humanity that we hope we try and bring to these cases.
It's a very difficult balance to be struck, but as you say, all anyone can do is their best, and it sounds to me that you know, that's certainly what's happening in the West Midlands as far as I can see. So thank you for dealing with that quite difficult point. Onto a more sort of technical or procedural matter now, which is a question from Emma Smith about bundles. And the question is this: I know the court prefer to have a searchable and bookmarked e-bundle, and we are able to produce these through Bundle Docs program in PDF format. However, sometimes they are of a very large file, and therefore the court do not accept them by email, or sometimes they automatically get converted by our server to be downloaded as a PDF from a secure site. But the court staff will not then download them, and they email us telling us to resend in another format. What that means is we then have to split the bundle down and scan it in manually, which then renders it unsearchable, and the bookmarks and all the tabs put in are lost. Can you let us know whether the court staff will increase the accepted file size by email, whether they will download these documents from secure sites as PDFs, or if not, does the court have any preferred format or software for us to send in our e-bundles? So I'm going to turn to District Judge Ingram to deal with that point about e-bundles, please.
Yes, thank you, Juliet. With the problems with e-bundles, I suppose might come from my ignorance in that I've never had to put an e-bundle together. And probably in my day when I was in practice, I don't really remember using PDFs very much either. When we first went into lockdown, we had the very basic version of Acrobat for PDFs. It did nothing. We have in the recent, I think probably the last 4 or 6 weeks, something like that, managed to be given through the MOJ PDF Expert, I think it's been called, which is a lot better. And it does allow us to search, and we can tab our own documents now, which we weren't able to do. One of my bugbears is parties and practitioners not doing a form of an e-bundle. And in the proper format, so it can be searchable and indexed. Sometimes we get them without even indexes, sometimes we get them without even pagination. I don't understand why that is, because I understand that after, again, as Judge McCabe has said, 12 weeks into lockdown, everybody by now knows that this is the way we're going forward, and should have perhaps looked on YouTube or whatever to work out how to do them so that they're in a court usable format. If we have separate documents, and often we get them by the court sending us 3, 4, 5 or 6 emails, each then having attached to them 4 or 5, 6 different PDF or Word attachments. We then have to download them. We then have to put them in a place where we can find them quickly for that hearing, often having to rename them when we save them, because they all come through as bundle 1 or bundle 2 or doc A, doc B, doc C. And they don't necessarily tell us if we have 12 or 13 documents open on a screen, very quickly which PDF we need to open to get to the section that they want. If you try yourselves at home or in the office, opening 12 PDFs, you will see how much of the title at the beginning is easily shown. So during a hearing which you're very short of time or you need to get a lot done, just work out, if I said, please Judge, could you turn to section E, page 356, how long it then would actually take you if you didn't know that bundle, how to get to section E, 346. Sometimes they don't even tab the sections. So you actually have to scroll the whole bundle you've got before you get to the bit that says E and then E346, which I'm sure can easily be done by tabbing, even if you just tab section A, B, C, D and E. So at least we can go to tab E quickly and then try and scroll to 346. If we've got time, I now know under the new PDF expert how to tab and bookmark pages of documents that I think you're going to refer to. But we don't always have time with that, mainly because a lot of the documents and e-bundles we get very shortly before the hearing and not enough time to do that. In any event, for most of the hearings, certainly for FDRs and FDAs, you should minimise the bundle so that it is possible to get it within that format. It is core documents only, and the number of times I have bundles that are 4 or 5 different bundles with over 1,000 pages, and I'll probably only be referred, as you know, probably to less than half a dozen pages. So there's got to be some negotiation, talking, communication beforehand with the other party to say what are the essential core documents that the court's going to need for this particular hearing, whether it's an FDA or an FDR, and make sure that you can then format a bundle that the court can readily and easily navigate. And having bundles or e-bundles that aren't indexed or paginated is simply not acceptable. And at this stage, going forward, it may well be that if we're under pressure and we have a lot of cases listed to get through, that bluntly your cases just simply would have to be adjourned off. So those are my comments. I'm sorry if they are ignorant as to the practicalities, because I've never done one. Just very briefly on the links, etc. Some of the links have been sent through to me via solicitors. I clicked on them and I just get a PDF bundle. That's fine. I save it and name it myself. And again, sometimes I've had, here's your bundle, but it involves me going to Intralink or a company where I have to download a license, whether I have to pay for it or not, it doesn't matter, because the Don Juan court software won't let us download it or get a license. So do be careful about sending us links to bundles, anything like that that requires us to sign anything up or use a license. We won't be able to access it. So, but links that don't seem to want us to do that seem to be fine. But it's just a point, the court, again, understaffed, under-resourced, got a lot to do, won't be able to manage all that, for you. And they just haven't got the time or the resources. So I don't know if that deals with the question or answers everything in the question. I think hopefully it does.
Thank you very much. So in terms of summary, that you really do need those tabs on the e-bundles. Yes. That's essential.
Indexed.
And if you're going to send the bundle as a link to a separate site, make sure it's one that can just be accessed with one click rather than one you have to sign into or download software for, essentially.
Absolutely, yes. And negotiating with the other side to get a good core bundle.
And are any of the judges using anything like Dropbox, which is obviously quite a popular provider of that kind of facility? Do any of the panel have any experience of that?
I do.
I'm just looking at the email I received last week for the case I'm trying at the moment. And I received my bundles via something called SafeDrop. And I received one email containing the link to the bundles and a further one with a link with the code that I had to enter, and I found that worked perfectly well.
So provided it's relatively simple, as you say, often they are password protected.
But if it's simple for the judge.
Yeah. So perhaps worth checking with the court if you're filing bundles on the judge's preference as well. That might be a good idea. In terms of,
or discuss it at the FDR if it's setting down a final hearing.
Yeah. Okay, thank you very much for those points on bundles. The final question in terms of the pre-submitted questions before we turn to the live Q&A is a question from Mercy Messenger. And I think it was going to be answered by you again, Robin. What platform will Birmingham Family Court be using for virtual hearings going forward so we can ensure our systems are compatible? Will the court be considering using Zoom in the future? Right.
Well, as you've heard, there are certain HMCTS approved platforms. And at the moment, Teams is an approved platform, whereas Zoom is not. for weeks now, if not months, judges have been trying to get HMCTS to approve Zoom. The theory is that there are security issues with Zoom, but I think it's acknowledged by most people who know anything about it that those security problems have been overcome because it now has end-to-end encryption. Nevertheless, Zoom is still blocked on judicial laptops. I'm having to join this webinar using my personal laptop because I can't do it via my judicial one. If I had a preference, I would want Zoom to be available, but it's way above my pay grade. And we're waiting a decision on that I hope will come soon. I have just completed an 11-day case where we used Zoom. I had to use my personal laptop so that I could access it. But the great advantage of using Zoom is that there are the private consultation facilities that are part of the arrangements that can be set up. And to my mind, that would work very well for financial dispute resolutions, where you could then have the private consultations taking place on the same platform between each party and their representatives. It would work much better. But until HMCTS unblock it, we've got a problem. Can I just mention one other factor to bear in mind on this use of platforms? My practice is to ask either counsel or solicitors to set up the meeting and send out the invitations. And that's something that I'm going to be encouraging other judges to do, because the reality is that the court staff are so stretched that court staff don't have the available time to do it. And if you're going to want to have your hearing effective, then I think that's an area where the legal representatives will have to take on a responsibility. So I ask for your cooperation in doing that, please.
Robin, can I just come in there, because that's just contradicts something that I said in a written answer. That's fine for judges in the building with darts, the recording equipment. If judges are working remotely, they have to set up the Skype or Teams hearing, because that gives them the ability to record it. And if they don't, I mean, I appreciate we're probably going to be back working in with darts available, so it may become less relevant. But that's why the judge has needed to do it, not the staff. It's basically sending an email.
But the judges using Teams can have the invitation also sent to a clerk if they're working from home, who's able to record. Now, it depends whether you've got a clerk available, and that will depend from court to court.
Yeah.
Also, the judge may be able to record it him or herself using Teams. Yeah. Okay, I hope that deals with the issue, Juliet. Is that all right?
Thank you very much indeed. That's very helpful in terms of the way forward for these video hearings. And clearly there's some, there's no uniform practice, and that's the reality. Some judges are working in the building, some judges are working from home, some judges have some support with court staff, some judges have none. So it really is a case of us all just trying to work as best we can on a case-by-case basis to make sure that the invitations are sent out as per the judge's preference, really. So would you say it's a safe assumption for practitioners to say if they haven't received an invitation to the video session, I don't know, two days before the hearing, that they ought to get on to try and organise it themselves, or not? Alternative Judge McCabe, who's still on mute. How far in advance are those tending to come out? About 24 hours or on the morning of the hearing?
Not even necessarily. You've got to remember that we can't send the invitations out until we've received the contact details or the parties. So it'll just depend. I mean, I sometimes don't get them until the morning,
So
and then send it out.
Yeah, so if the court needs the lawyers to set it up, presumably, Robin, you'll be telling the lawyers that well in advance. They'll receive notice of that.
If I'm setting up a remote hearing, one of the standard directions is going to be who is responsible for setting up the invitations, what platform we're to use.
Yeah.
Now that we're getting an understanding of how these remote hearings take place, that needs to be part of the case management. As I think I said earlier, we've got to case manage these cases to within an inch of their lives if they're going to be effective. Up till now, we've been trying to look ahead a few days to what's in our lists and then identify what platform we're to use, try and contact one or more of the representatives to try and sort out these practical arrangements. But doing it on that sort of last minute basis, to my mind, needs to be rethought, and it needs to be done whenever the next hearing is being set up.
Yeah. So we should be moving to a system where it's clear from the directions that have been given where the responsibility lies and which platform will be used, etc.
Yes. Lovely.
Now we are pretty much out of time. I'm going to deal with one point on substantive law that was pre-submitted, which is a question about whether, if one works on the basis that residential property prices will be negatively affected by the pandemic, could any substantive changes in value over the months immediately preceding the onset be argued as BARDA events? As I set out at the beginning of the webinar, we're not going to deal with any substantive legal issues in this webinar, but in fact there is a webinar on just that point already been given by Leisha Bond from the St Philip's family team. So if anyone's interested in the answer to that question specifically, we can give you the link to Leisha's webinar on that point. And I think there's an article as well. So you'll have an answer to that from Leisha. There've been a lot of questions raised on the live Q&A and also quite a lot of them answered, and I'm grateful to the panelists for dealing with those whilst they've been on the webinar. I'm just going to turn to a couple of the open questions if I can, just to try and squeeze those in. I wish we should have buzzers or something, so I'm going to read the question. If anyone wants to volunteer, they can buzz. I don't know if we've got anything handy you could use as a buzzer, but what would be the best or most appropriate procedure for an urgent Section 37 application? Anyone want to volunteer for that one? How do we get, in these remote times, how do we get an urgent Section 37 application before a court quickly and speedily?
Well, send an email marked urgent to the FRC inbox. Mark it high importance, and we do try and pick up things that are truly urgent. If after an appropriate period of time it's not answered, and assuming that nobody on this webinar is going to abuse the process, I know Judge Ingram and I have picked up emails from solicitors who have contacted us with genuinely urgent cases, and we've made the right directions.
Thank you.
Judge Ingram, are you happy with that response?
Yes, I did try to answer. I'm not very good at the text, she says, and answering online, but I did try to. We do and have dealt with, and I have dealt with urgent Section 37 hearings. The important thing is, because the staff have so many, that you need to flag up in the subject matter line how urgent it is, and the staff are relatively good at forwarding them normally to the FR box or myself or Judge Rowland to give directions. So we can manage those, and think Robin gave a good answer. Yeah, I agree with that.
A quick one from Michael George, who would like the panel's views on private FDRs, and in particular the situation where there's been a private FDR but then which fails, and then one party seeks to have a second court-based FDR. What's your likely sort of judicial view on that scenario, or is it difficult to say in a general way?
I think my view would be, if it's been a properly arranged private FDR that has failed, it's unlikely that there would be a court-based FDR, there would have to be a good reason. For example, the private FDR couldn't go ahead because of a poor disclosure or something of that sort, and that the court FDR would be in a better position than the private FDR was.
So unless there's good reason for a second bite of the cherry, it would really be a situation of getting it in for directions and listing for final hearing.
Correct.
Thank you very much. A quick bundles question. In fact, we've got a couple of quick bundles questions, and I'm going to try and merge them. One's from Maria Ramon and one's from Mark Hands. Really, these are saying, what steps are the court taking to make it easier to send bundles, e.g. intralinks, to enable the download of a searchable bundle? And Mark Hands wants to know, how helpful is it to a judge for an e-bundle to be searchable? Because this is very time consuming for practitioners, and they're always happy to help the judges, of course. In my experience, there's a large variation as to what judges are expecting. Is a general preference. So we've heard from District Judge Ingram that the idea of there at least being some basic tabbing, that's really important to enable you to navigate the bundle. But what about searchability? How essential is that?
Well, from my point of view, I think part of our directions have made it clear in the court order that it should be paginated, indexed and searchable. It very rarely is. But from the court order point of view, that's what is ordered, that is what's required. It's just a question that you need to make sure that you get the best out of the judge and the best out of the hearing for your parties if they're spending that amount of money. And I'm afraid the preparation, just like it's going to take us, the judges, longer to prepare and read for the case because everything has to be done online. Please remember as well, we don't have access to printers. We're working from home. We cannot attach our DOM 1 to a printer. We've recently been told we can, but quite a few of us district judges at Birmingham haven't managed to do it. So we have to read everything online. And if we're taking twice as long online to try to read it, to give you a good case, a good hearing and a good view and good case management robustly, then I'm afraid you're just going to have to spend the time on making sure that you get the most out of that court hearing by putting the prep in. So from my point of view, it is important. And I don't know what the other judges think. Perhaps I'm being too harsh. We don't always get it.
There's another question about hyperlinked indexes, which is, of course, another feature which can be helpful. How important is the hyperlinking, or do you just think bookmarking is sufficient?
From my point of, sorry, Louise?
No. Go.
I was just saying, from my point of view, bookmarking, I find, and searchability is better than highlighting the links within the document. I personally find that a better format, but others might think different. Lou, you wanted to say something?
I think, yeah, what I was going to say is, I don't know if, I know Mostyn is very clear that we will all be dealing with final hearings with e-bundles only. For those working on one screen, that's obviously almost impossible. And certainly for Coventry, the directions are going to say final hearings still need paper bundles. So we're really talking about FDAs and FDRs. One thing I would say is I think more thought needs to be given to filleting the bundle down. Hyperlinks are great, bookmarks are great, anything that helps us is great, but actually the best thing you can do is really think about what actually needs to be in the bundle. The bundle shouldn't need to be that large for an FDR hearing if really careful thought has been put into what's in that bundle in the first place. So you can have the best technology in the world, but it's still going to be an unmanageable bundle potentially if it's got far more documents in than are required.
Thank you very much. Now, I'm aware that we've probably gone significantly over time. There's just one question here, which I'm going to raise from Leisha Bond, because I think it's something that may well be of concern to practitioners, which is this. It's a question for His Honour Judge Rowland. There have been occasions when judges have asked counsel to record hearings themselves, and this causes me very real concern. What is your view on this?
Well, the court should ordinarily make the recording. I think that's really the long and the short of it.
Yes. So
Well, offence for anyone else to do it, isn't it?
That may well be right. If
That's what I always tell everybody.
Yeah.
If they've been asked to, it probably isn't contempt. But certainly there should be no unauthorised recording. But you know, it's only if the court has done the recording that there's proper control over it.
And thank you. Now this really is the last question. I'm just going to take this, that it's cropped up a couple of times now in the Q&A. There've been a couple of questions raised about the situation if a hearing is listed to take place in person, or I suppose it would also apply if it were listed as a hybrid hearing, the either counsel or the client says, sorry, I cannot attend because the child is not at school or not able to attend a school setting, I don't have childcare. And I suppose it would also apply if that person said, sorry, I'm having to shield. In either of those scenarios, would the court reconsider the listing arrangements and say, okay, it will proceed remotely in those circumstances? Or will the court expect attendance, as was always previously the case prior to COVID? Again, I'm hoping for a volunteer.
I think you'd have to, as somebody with school children age, I think you'd have to say that the case would be considered on its merits. So is this an attempt to cause delay in circumstances where there have been months and months of delay? Is it genuine? Has this person got nobody in that bubble that can babysit like they would have to if we weren't in COVID? I think it's impossible for us to give clear answers. You can hear my dog's barking, sorry, in the background. I knew this would happen. To give clear, right, I'm going to stop now. Case by case, I think.
A case-by-case approach to that one. Thank you very much indeed. May I just, to finish off, thank all the panellists for giving up their time to come and do this webinar. You've answered a huge number of questions, far more than I think I told you it was going to involve. So I'm sorry about that, but thank you ever so much. I think I can see from the comments that people have found it enormously helpful. So we're all very grateful, and we look forward to seeing you all, if remotely, soon. Thank you.
Bye-bye. Thank you.
Goodbye.